Hello, and welcome to the Syverson, Lesowitz and Gebelin Cyber Liability Update. Real quick hit for you all this week. If there's one question that I get asked more than any other in my cyber liability practice, I would say not a week goes by that I don't take a call from someone who either already has a judgment or wants to obtain a judgment for defamation against someone or some company for content posted on a social media site, user-generated content such as Yelp or Facebook or Google reviews. And the question I get is, yes, I want to sue this person for defamation and I want to get awarded money, but I also want the content, the defamatory review removed. So the question is, let's use Yelp as an example. Let's say there's a defamatory review on Yelp. The plaintiff proceeds and obtains a judgment against individual X. Well, that brings up an issue because although the content was authored by the defendant, the content appears on a website like Glassdoor or Yelp or Ripoff Report or many of these other review type of sites that are such bastions of defamation. So you've got your judgment, but Yelp or Glassdoor, they were not a party to the lawsuit. So the question under California law recently arose in that when the plaintiff obtains that judgment, which we're really talking about the permanent injunction portion, so on this type of defamation judgment, there will be a permanent injunction ordering the defamatory content to be removed. But again, Yelp and Glassdoor were not a party. The permanent injunction is arguably enforceable only against parties to the litigation, or so many people thought. In a case called Hassel v. Bird, this situation arose, and Yelp was ordered by a trial court to obey the permanent injunction, although Yelp wasn't a party to the lawsuit. And Yelp jumped up and down and said, hey, this is crazy. You can't, this is a violation of our due process. Au contraire, the California Court of Appeals said, no, you are a tool or an instrument of the wrongdoer, therefore you are contained underneath the scope of this permanent injunction. And Yelp and every other social media company and important internet company in the world has joined forces and taken this issue up to the California Supreme Court, and I'm making a cyber liability update about it today, not to announce a decision, which would be great because we're all sitting on the edge of our seats to see how the California Supreme Court rules. Will it uphold the trial court, the appellate court? And if it does, then if you are being defamed online on one of these sites, Ripoff Report, Glassdoor, Yelp, Google Reviews, any website you can think of where user-generated content appears and where defamation takes place, you will have an effective new powerful tool under California law. These third-party website content hosts, if you will, are going to have to rethink their policies because although they will not be parties to lawsuits, they will be seen as tools of wrongdoing, and they will have to obey permanent injunction orders. That's the Syverson, Lesowitz and Gebelin cyber liability update, or maybe I should say non-update. But you better believe when we get some clarity from the California Supreme Court, I'll be back here making my low production values videos and tell you how it turned out. Hassel v. Bird. In the meantime, we're still doing as many defamation cases, both as plaintiffs and defendants, as any law firm in the country because we are America's top cyber liability law firm. That's all for now.